property, custody. We have your legal questions, and lawyer David Hollingsworth is here to answer them.
I love free legal advice, and we know you do as well. Leanne Cusack is with lawyer David Hollingsworth. Lily.
And as a lawyer, you do end up giving out quite a lot of free legal advice. We have a number of questions David is going to answer. But first, bar none, the most common question you get is relating to bars and drinking.
Certainly recently, Leanne, I can't tell you how many calls I've received from usually concerned parents with respect to alcohol-related injuries that a loved one has suffered, usually at a bar or after somebody's been to a bar, whether it's somebody's fallen down and hurt themselves, or there's been an assault by a staff member, another patron, or unfortunately a drinking and driving incident. And while our courts recognize pretty clearly that people are responsible for their own actions, increasingly the courts are imposing liability on the establishments that overserve these individuals who go out and then ultimately get into difficulty. Of course, the bars do, the servers are required to take smart serve courses. They detect whether somebody's intoxicated, whether they're of age and whatnot. But now the courts are really holding the bars to a high standard to make sure that they meet those rules of smart serve. And there have
been a number of prominent cases. One situation that's sort of a spin-off of that is if someone's been to a bar, they've been overserved, and end up at your home for a party or just for a visit, then what happens?
Well, I guess it depends on what happens. If they arrive at your home and they create a problem of some sort, they're aggressive, they break things, who knows what, and you've suffered a loss, then potentially you might have a claim against the bar where they were overserved, because gone are the days where a bar can simply sort of let somebody leave and wipe their hands of it and send them off into the night. They now have greater obligations.
You used the example of at one point it was a bouncer's job to sort of keep the peace, ensure there weren't too many fights. Now it's a bouncer's job to ensure a patron safely gets into a cab almost.
More and more, exactly. The bouncers and the staff have to ensure that the people get home safely. I had a very unfortunate case that I was involved in a couple of years ago where 4 young men went out for a night on the town. They went to a bar, allegedly spent close to $2,000 on alcohol. The staff all knew them, and as the bouncers ushered them out the door at the end of the night, without incident, they hopped into a vehicle, and lo and behold, a couple of kilometers down the road were involved in a serious collision. 1 of them died, 3 of them were injured for life. And that's an example of a case where, it was found that the bar was very substantially liable for this serious incident that occurred. Whereas 25 years ago, a bar might have been 10% liable. Now the courts are saying, no, 30, 50+% responsibility for these incidents.
A very interesting topic, and other topics are generated by your questions. We have time to get to one question before the break, and then we'll come back with more. This one is also liability. I slipped on some gravel that was left on a sidewalk from a neighboring construction site and needed surgery. What are my options if I want to sue?
Okay, well, firstly, if it's a city sidewalk, you're required to notify the city within 10 days of an incident that occurs on city property. But the added element here is that there may have been a hazard that was placed from somebody other than the city, and that would be, let's say, the builder next door. And so you potentially would have a claim against the builder who created the hazard, and potentially the city if they didn't deal with the hazard appropriately.
We're out of time, which leads me to statute of limitations. If in fact that happens and it's the builder's fault, what's the statute of limitations on that? 2 years. We're going to be back with more of David's free legal advice. And Michael, I know in the commercial break you will come up with a question, right? Ottawa lawyer David Hollingsworth is here to answer your questions, and as predicted, Michael did have a question in the commercial break, not to offend a neighbor or anyone in the neighborhood, but Michael asked David if a homeowner takes great care of their property and the neighbor does not, it's a junkyard, what rights does the homeowner have?
Has Michael received a complaint?
Touche.
People will call city property standards. There are bylaws and there are obligations that a homeowner has to maintain their property, and that's governed by the city of the municipality, the city of Ottawa. To the extent that their garbage or their junk is encroaching upon your property and they're damaging your property, you would have a potentially a claim and a trespass of some sort.
But how long would it actually take to get the ball rolling on that? It sounds like it's the kind of thing that, would take a while to
Well,
Actualized.
I mean, what happens actually is that the city comes out, and if an inspector comes out and they do their inspection, and what they'll do is they'll place a work order against the property, and they give the homeowner a certain amount of time to remedy the situation. Otherwise, there are means by which they can come and do it and charge the homeowner back, and it can become like a lien against the property.
I think that's a question that probably relates to a lot of viewers, and this as well, because you get tons of workplace injury questions.
I do.
This isn't a workplace injury, but this relates to employment and someone who was off sick. So this person was off sick from work, and the boss said that a doctor's note had to be produced.
Okay.
Is she allowed to do that? Can she fire me if I don't produce a note?
Okay, typically unless there's a contract, and even if there's a contract, the Employment Standard Act is what applies here. And a boss can require reasonable evidence. If you're going to be off on a personal emergency sick day, they can ask for reasonable evidence as to why you're off. And assuming you're able to produce something that's reasonable, then they can't fire you as a result.
All right, we're going to move on to something you've mentioned before on the program, and I actually can't remember the answer. What are contingency fees?
Okay.
How do they work?
Contingency fees are essentially, that's where the lawyer will wait until a matter is settled and compensation is received by their client before they get paid. So basically, they'll take, usually it's done on the basis of a percentage of the settlement is how the lawyer gets paid. And the Law Society of Upper Canada permits this, but they've got very strict rules as to what the lawyer must do and what the client must do to be allowed to have a contingency arrangement.
So that relates to only someone who's involved in a legal dispute or a legal case?
Where there's ultimately going to be a payout of some sort.
Okay. Now, this relates to probably more of our viewers. My husband and I are separated. Is my old will still valid, and what happens to my pension now that we're separated?
Okay, sorry, so they're separated, not divorced, and so essentially the will is still valid. Okay, so if you're separated and not divorced, then the will is as is. So if you want to not have your spouse be in the will, then you better go change your will as quickly as possible. And the second part was about the pension?
Yes, what happens to the pension now that we're separated?
Okay.
Now, the person asking the question didn't indicate whether it was a virtual separation or a legal separation,
well,
so I'm not sure.
You know, eventually, ultimately, when there's a separation and the assets are going to be divided, the pension becomes an asset. It becomes an asset for the purposes of dividing assets between spouses.
But if, in fact, someone is divorced, let's elaborate on that a little bit, a will is no longer valid?
Okay, so if let's say I've got a will and I designate my spouse as beneficiary and estate trustee, if we then get divorced, but I don't change my will is still valid, but the law treats my spouse as dead.
And that would be problematic if, in fact, your spouse was, in fact, the executor.
Well, yeah, and so the will basically becomes potentially meaningless because you don't have an executor, you don't have a beneficiary. But it's funny, that's basically when somebody says you're dead to me, it might mean that you're dead in my will, because once they're divorced, that's how it's treated.
Okay, you ready for the next one?
I'm ready.
Okay, this is sort of like being on a game show, isn't it,
Sure.
for you, David?
Lay it
Okay,
on.
I'll give you a chance to take a breath. I have been renting the same place for 12 years. The steps are all rotten. I've asked my landlord to fix this. 2 weeks ago, no sign of it being fixed. It's so dangerous. I'm nervous getting up to my apartment. What
Right.
can I do?
Okay, well, first I would want to make sure that any complaint about this is in writing to the landlord. Secondly, you can apply to the Ontario Rental Housing Tribunal to have an order that the landlord must repair this, and furthermore, that you might get an abatement of rent for the time that you couldn't enjoy your property the same way you ought to have been able to if the stairs were in proper repair. And then, I guess finally, if you have enough money, if you can afford it, you can get the stairs fixed yourself and then ask the housing tribunal to require your landlord to reimburse you for that.
Our next question, which we don't have time for, is about inheritance, and it's a really interesting one, so we'll have to have you answer that the next time you're on the program. And there's a link on our website. If you have a legal question you would like to ask David Hollingsworth, we will explore it on the program in about 6 to 8 weeks' time.
Great.
We want to thank you now. You can take a breath.
Okay, thanks.
And there is
Leanne.
that link on our website as promised. Michael.